Every year, business owners and corporate directors across Florida get blindsided by a lawsuit filed by their own shareholders. Not a competitor, not a regulator, their own people. And the worst part, most of those lawsuits could have been prevented entirely. The reason why most directors lose derivative actions has nothing to do with the merits of their decision. It has everything to do with the steps they skipped before they made that decision. And in this video, I'm going to show you the exact defense framework, what I call the Boardroom Shield, that stops a Florida shareholder derivative lawsuit before it ever reaches a courtroom. By the end of this video, you'll understand the specific safe harbors under Florida's Business Corporation Act that protects your decisions from judicial second guessing and the fatal mistakes that strip that protection away overnight. All right, let's dive in. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I work with directors, officers, and business owners in the state every single day, and I can tell you that understanding these defenses is the difference between sleeping soundly and getting served with a summons. Now, here's what most people get wrong. They hear the phrase business judgment rule, and they think it's some kind of automatic get-out-of-jail card. They assume that every decision a Florida board makes is protected. That's not how it works. Actually, the business judgment rule under Florida law is a presumption. Courts presume that directors acted in good faith within the scope of their authority and in the honest belief that their decision served the company's best interests. Florida codified this protection in Section 607.0831 of the Florida Business Corporation Act. But here's the thing, that presumption can be destroyed, and when it is, the consequences are severe. I call the moment you lose that protection the trapdoor. One moment you're standing on solid ground of judicial deference, the next you've fallen into the most plaintiff-friendly territory in corporate litigation. Now, what makes Florida unique is that Section 607.0831 specifically lists the conditions under which a director becomes personally liable for monetary damages. This is not some vague common law standard. It is a statute. And the statute says that if a director's breach of duty constitutes a conscious disregard for the best interests of the corporation, the business judgment rule will not save them. So the real question isn't whether the business judgment rule exists in Florida. The question is, how do you make sure the trapdoor never opens? Now you're probably thinking, okay, so what exactly triggers conscious disregard in Florida? That's exactly what we need to talk about here. The first layer of the Boardroom Shield in Florida is something called the demand requirement. This is your front gate. Before a shareholder can file a derivative lawsuit on behalf of a Florida corporation, they must first make a written demand on the board of directors under Section 607.0742 of the revised FBCA. Then the shareholder must wait. Florida law gives the board 90 days to respond to that demand. 90 days. That is an enormous window. And the reason why this matters so much is that during those 90 days, the board gets to investigate the claim and decide whether pursuing the lawsuit is actually in the corporation's best interest. And that decision itself is protected by the business judgment rule. So think about what just happened. The shareholder tried to sue. Instead, the board got to decide whether the lawsuit should even exist. But here's where Florida gets interesting. The revised FBCA, which took effect January 1st of 2020, changed the rules. Under the old statute, the demand was mandatory, no exceptions. Florida courts repeatedly confirmed there was no futility exception for corporations, and the Third District of Appeal in Rappaport v. Share made this clear. Now, under the current version of Section 607.0742, a shareholder can allege that making a demand would be futile. They must identify in the complaint the specific reasons why they believe the demand would accomplish nothing. This was a significant shift. It brought Florida's corporate statute closer to what already existed for LLCs under Section 605.0802 of the Florida Revised Limited Liability Company Act. All right, so what does this mean for directors? It means the demand requirement is still a powerful shield, but it is no longer an impenetrable wall. Shareholders now have a doorway they didn't have before, and the directors who ignore that reality are the ones who end up in court. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now, here's where it gets really interesting. Let's say a majority of your board has a personal stake in the transaction being challenged. The demand defense weakens because the shareholder can argue futility. Most people think the game is over at that point. Actually, it's not. This is where smart Florida boards deploy what I call the clean room strategy, the Independent Litigation Committee. Under Section 607.0744 of the revised FBCA, the board can appoint a committee of qualified directors to investigate the derivative claim. These must be truly independent directors who meet the definition set out in Section 607.0143. They can even be individuals bought in from the outside the company specifically for this purpose. That committee investigates the claim and makes a recommendation. Now, here's the critical part that separates Florida from many other states. Under the Florida statute, the corporation bears the burden of proving that the committee was independent, that it acted in good faith, and that it followed reasonable investigation procedures. The shareholder does not have to prove the committee was tainted. The company must prove it was clean. This is a higher standard than what you'll find in some other jurisdictions. And here's another wrinkle that makes Florida unique. The statute says the court may dismiss the derivative proceedings based on the committee's recommendation. It does not say shall. That single word, may, instead of shall, is a deliberate departure from the Model Business Corporation Act. It gives Florida judges discretion to let the case proceed even when the committee recommends dismissal. I call this the judge's escape hatch. It means that even a perfectly conducted investigation doesn't guarantee that the lawsuit disappears. All right, so what does this mean for you? It means the clean room strategy works in Florida, but only when the investigation is thorough, the committee is genuinely independent, and the report withstands scrutiny. Now let's talk about the single biggest mistake Florida directors make, the one that blows up the Boardroom Shield entirely. I call this the Sleepwalker trap. It catches directors who are passive, who rubber stamp decisions, who don't read the materials before a board meeting. Under Florida Statute 607.0831, a director is not liable for monetary damages unless the director's conduct falls into one of several specific categories. The one that catches the most directors off guard is subsection 1B4. Conscious disregard for the best interest of the corporation. Notice that Florida's standard is not mere negligence. A bad decision alone won't create liability, but conscious disregard is different. It means you knew you should have paid attention and you chose not to. You knew there was a conflict of interest and you looked the other way. You knew the transaction was questionable and you voted yes without asking a single question. And here's what makes this dangerous. Florida's attorneys in Florida shareholder derivative lawsuits have learned to plead conscious disregard in almost every complaint. The reason why this is so effective is that it creates a factual question that's difficult to resolve and a motion to dismiss. The judge looks at the complaint and sees an allegation that sounds like more than ordinary negligence, and the case survives. The directors who avoid the sleepwalker trap are the ones who document everything. They ask questions during meetings. They request independent evaluations, they obtain written opinions from advisors, and they create a paper trail that proves they were awake, engaged, and acting in the corporation's interest. Now, you might be wondering how national trends affect Florida directors in 2026, and let me give you the bigger picture. Delaware, which has historically set the pace for corporate law, has been moving in a dramatically more director-friendly direction. The Delaware Supreme Court decisions in Maffei versus Palkin and the Tornetta versus Musk Tesla litigation both signaled stronger protections for board decisions. Delaware also passed Senate Bill 21, which broadens the availability of business judgment rule protections and tightens the definition of controlling shareholder. Meanwhile, Texas passed State Bill 29, which allows publicly traded corporations to set minimum ownership thresholds for shareholders who want to bring derivative claims. And just recently, in March of 2026, a federal court decision in Kaczynski versus Reynolds upheld this approach, effectively shutting out small shareholders from derivative litigation. All right, so where does Florida stand in all this? Florida has historically followed Delaware's lead in corporate governance law, but the revised FBCA introduced the demand futility exception, which actually expanded shareholder access to derivative litigation, the opposite direction from what Texas is doing. Florida sits in the middle. The business judgment rule remains strong here. The demand requirement remains a powerful first defense, but the futility exception and the court's discretionary power under the litigation committee provisions means that Florida directors cannot afford to be complacent. The bottom line for Florida corporate boards is this: the national trend favors directors, but Florida's statute gives courts more flexibility than Delaware or Texas. That means process matters more here than almost anywhere else. So let me bring all of this together into what I call the Boardroom Shield checklist, the framework that stops a Florida shareholder derivative lawsuit before it even starts. Layer 1 is a demand requirement. Make it work for you by responding to every shareholder demand in writing, promptly, and with a documented investigation. Layer 2 is board independence. Ensure that a majority of directors have no personal financial interest in the transaction they approve. And Layer 3 is the clean room. Be prepared to appoint an independent litigation committee under Section 607.0744 the moment a derivative claim surfaces. And Layer 4 is defeating the sleepwalker trap. Document your deliberation process. Ask hard questions. Get independent opinions. Create a record that proves conscious engagement with every major decision. When you layer these 4 defenses together, you build something that is extraordinarily difficult for any shareholder plaintiff to penetrate. Not impossible, but close. If this video helped you understand how to protect yourself and your board from a shareholder derivative lawsuit in Florida, hit that like button right now and subscribe to this channel so you never miss an update when the law changes. And share this with your partners, your co-directors, and anyone who sits on a board. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.